very much, Ruth, for this generous introduction. You also bestowed a PhD on me that I don't have, so I just wanted to clarify that. But really a huge thanks to all the organizers of this important webinar. I'm delighted to participate in it and really, really congratulate you on holding this important webinar. I want to start off on a positive note to say that I think we have come a long way. I think that over the last few years, for the first time, the human rights consequences of gendered child custody issues and their application has come, as you said, have entered into the collective, are being discussed from a human rights perspective in international fora, including the UN, including also the application or the misapplication of the Hague Abduction Convention. And if this has become possible, it is really thanks to the tireless efforts of many organizations like the ones who are organized this webinar, but also the many experts that have for long defended the rights of women, mothers, and their children, have drawn attention to their experiences, and of course, the many courageous, relentless survivors of this violence, be it the women or their children. And I know many of those that I've just mentioned are with us here today. I think it's also extraordinary that thanks to these advocacy efforts and very meticulous organization and dissemination of information, victim organizations and survivors, or survivor organizations and survivors, have managed to make their voices heard and even get the Bureau of the Hague Conference on Private International Law and member states to now pay attention and to realize that they have to do something about the experiences of mothers and their children and the abuse that they suffer. Of course, much remains to be done, but I wanted to take a moment to actually take stock of this and realize that we have come a long way. I think collectively we tend to focus on what still remains to be done, but I think we should also take stock and recognize what has been done, often at grave and great personal risks, in the face of threats, in the face of intimidation, in the face of actual punishment, a lot of heartache, and a lot of pain. And of course, this webinar is one of the indications that we all realize that we have to keep this momentum going. And one of the ways of doing that is also to spread more information and awareness about the issues and the experiences and what actually is the problem with the application of the Hague Convention at the moment. So Ruth mentioned that in 2023, I issued a report to the Human Rights Council of the United Nations on child custody and violence against women and girls. And in fact, until that point, whatever was happening in family courts was not really thought of as a human rights issue. And so I still remember that at the time, there were a lot of, let's say, delegates of UN member states that raised their eyebrows. Perhaps some didn't quite understand why I was mentioning this issue in the Human Rights Council. And amongst the many issues that the report contained was also the reference to the application of the Hague Abduction Convention. Now, the main objective of the report was to shed light on the harmful dynamics of child custody cases and the way particularly family courts engaged on them. I tried to show through the report that child custody disputes often become another tool in the continuum of abuse, with perpetrators, usually the fathers, going as far as accusing mothers quite regularly of alienating their children from them and then weaponizing these allegations against the mothers, often leading the mothers to lose custody or leading the mothers to have to flee with their children because otherwise the child would be forced back to the father and forced back into a situation of abuse. Now, like the broader dynamic of child custody proceedings, the way the Hague Abduction Convention is being applied is also deeply flawed against mothers, and therefore it's also applied in a very gendered manner. It has often disregarded the safety and rights of the children and the mothers fleeing abusive situation. So instead of protecting children and by extension their mothers against abuse, they have prompted the return of children to their habitual residence, forcing them back into the arms of their abusers, forcing them back into dangerous environments, which they were trying to flee to begin with. And of course, mothers would not be taking this decision of fleeing with their children if they had the opportunity to have the history of domestic violence that they were suffering being taken seriously in the country where they were living by the courts and by the apparatus of the state. And just like the broader issue of child custody, the Hague Convention, as I said, is also gendered in its consequences. At the time I was writing the report, I actually did have access to data that showed at the time even, so we were saying 2023, that around 3/4 of all cases filed under the Hague Convention are against mothers. So clearly already we can see the gendered angle. And also the reports from states, parties to the Permanent Bureau of the Hague, parties to the Hague Conference on Private International Law, showed that domestic abuse had occurred in a significant number of these cases where cases filed under the Hague Convention against mothers. And so, I mean, despite the fact that in practice the Hague Convention really does not protect children and their mothers against abuse, we of course should know that the Hague Convention does have safeguards built into it that can be activated if there is a danger, if there's a reasonable danger, that the children may be returned to a situation of abuse and danger. And these safeguards are primarily there through Article 13(1)b and Article 20. Now, Article 20 provides that a court may refuse to return a child if the return would not be permitted by the fundamental principles of a requested state relating to the protection of human rights and fundamental freedoms. And of course, all states are parties to key international human rights treaties. They must uphold international human rights law and principles. And so that also pertains to the international human rights principles and treaties governing the treatment of women and children, non-discrimination against women and children, and also upholding their safety and dignity. So therefore, if we look at Article 20, in accordance with Article 20, states have an obligation to exercise also due diligence to punish past incidents of domestic violence and prevent future incidents of domestic violence from happening. And also they have a duty to rehabilitate the victims against the abuser, which in this case would be the taking parent. And we know that the principle of the best interest of the child, which as I'm sure is also known to most of us here, is articulated in Article 3 of the Convention on the Rights of the Child, is also a fundamental standard that has been incorporated in the national legislations of, I would say, most, if not all, countries that have signed the Convention on the Right of the Child. So that principle requires that the well-being of children be the primary consideration in all actions and decisions affecting them, whether by public or private institutions, courts, administrative authorities, or legislative bodies. The other article that in theory or legally speaking could act as a safeguard is Article 13.1b, and it states, Article 13.1b of the Hague Abduction Convention states that a court may refuse to order the return of the child if the person opposing the return can prove that there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. So again, as we said, Article 3 of the Convention on the Rights of the Child comes in here automatically, but another also standard comes in, which is the obligation to prevent or prohibit torture, inhumane or degrading treatment. And that principle is reflected in Common Article, Article 3 of the Convention on the Prevention of Torture, that frankly many, if not most countries are parties to. And therefore, allowing the return of a victim, be it the mother or the child, to the abuser can result, as we know from experience, in situations that could amount to torture, inhumane or degrading treatment. And therefore, that has to also be looked at before returning a child. And by extension, then forcing the mother perhaps to also return with the child. Now, in international law, the risk of torture does not need to be absolute, but it must be reasonable and present. Also related to the above, there is a firm principle in international law, namely the principle of non-refoulement. Said in layman's term, it is the prohibition of returning someone to a place or a country where they may be at grave risk or where their lives may be in danger. So that danger may be harm, whether it's physical or psychological or otherwise. It may also be torture. It may be also the threat of killing or loss of life. Now, despite these articles being there in the text of the Hague Abduction Convention, what we all have collectively ascertained is that these articles are rarely activated or rarely used. And one of the reasons, not the only reason, but one of the reasons is, again, this gender bias. The judges that examine the application of the Hague Abduction Convention have that bias. And so they will not tend to really identify or take seriously the history of domestic violence that the child and their mother may be running away from, nor take into consideration the continued threat of this violence if they were to be returned. And even if they may have some rudimentary awareness of it, they may not be equipped to recognize the dynamics of this violence, which could also include coercive control. And we all know how difficult it is to identify and recognize coercive control dynamics not all legal frameworks even recognize coercive control as a form of, let's say, domestic violence or gender-based violence. So, therefore, this is why it doesn't get activated, and this is also often why then the child gets sent back almost automatically to a very harmful situation. And as I said, what we see in courts that look at the Hague Abduction Convention mirrors what we see generally in family courts across the globe, that unfortunately they do tend to dismiss the history of domestic violence, or including sexual violence and abuse, including in custody cases, especially including, I would say, in cases where mothers or their children have brought forward quite credible allegations, but they often get dismissed. So yeah, and one of the ways also we see this is in this whole dynamic of parental alienation allegations, which is the main sort of dynamics also that my report was looking at. So what we have demanded, and when I say we, I mean myself and also other mandate holders or other special procedures of the Human Rights Council. So we have recommended that these articles and their use be activated and used much more robustly. Actually, I should also say that in the report of 2023, I was more ambitious and went as far as asking for the amendment of the Hague Convention to explicitly allow for a stay of return in cases with a history of where domestic abuse history was present, to enable the taking parent to litigate in a safe location while the court in the country of habitual residence of the child determines the safety and welfare issues. Now, I still stand behind that recommendation, and at the same time, I have become aware since then that, and maybe Ruth and others could also correct me on this, but we have noted that there is really no appetite for embarking on a course of amending the Hague Abduction Convention, neither by the Bureau nor by the member states. So therefore, we have also continued to stress on the need of using and invoking Articles 20 and 13(1)b, and calling upon states to also therefore implement the Hague Abduction Convention in a way that is consistent with their international human rights obligation. Now, I will just perhaps close by saying that we have made these recommendations in a very formal manner. Many of you may have seen that letter that I and others have sent to the Secretary General of the Hague Conference on Private International Law. It is a letter dated 19th of September 2023. We asked that this letter be shared with all member states. So in that letter, we made these recommendations I have just shared with you. And in addition to these recommendations, we also had recommended the establishment of a working group with experts on domestic violence and child abuse, as well as academics, lawyers, and representatives from survivors, civil society organizations, and for this working group also to apply really a gender lens to address inequalities. We also recommended strengthening the Guide to Good Practice under Article 13(1)b that the Bureau has by broadly defining domestic abuse, prohibiting perpetrators from using parental alienation claims to deflect abuse allegations, and linking the whole process of examining Article 13(1)(b) to the international obligations that states have against torture and the principle of non-refoulement. And finally, in that letter, we have recommended that states amend their domestic laws to explicitly recognize domestic abuse as creating a grave risk of harm and mandate judicial training on gender bias and abuse dynamics, as well as ensure legal aid and expert assessments, and implement all of that in a way that is also child sensitive, to listen to the child, to center the child and the child's best interest in all proceedings. Now, as others will say, I have tried to engage more with the Bureau and also to participate in these annual conferences of the Hague, Hague Conference on Private International Law. Unfortunately, it hasn't really been possible as much as I would have liked to, but I'm very reassured by the participation of some of the experts and organizations that are much more informed, actually, and more important than us, the mechanisms, because they are the ones who convey the voices of the survivors and can continue to demand robust accountability for the actions or lack of actions of states. So I will stop here and thank you once again for having me, and I look forward to the rest of this session. Thank you.